then 21 years.
This comes up after notice. The petition under section 11 of the arbitration act.
Yes.
Because last time on 14th of August when the matter came up, Your Lordship asked me to give 3 names of retired judges. I gave 3 names. One was Justice K.L. Vande, Justice Davre, and Justice Sarat. It was listed on 18th of August for that purpose only. On that day, my friend sought time, and therefore Your Lordship had imposed a cost of 1 lakh on 18th of August. Now, out of these 3, what happens in between is when I file a petition before Your Lordship, they appoint one lawyer unilaterally without my consent and get an award passed in their favor. Your Lordship indicated to them, this can't sustain. You choose one amongst retired judges, or you choose any one retired judge.
Now, whom do you want to go to arbitration?
Can I speak to respect? First, in terms of, I wasn't there at the last hearing, so I don't know what transpired. So for my learned friend to say that, well, everything, I don't have to argue anything and they're only looking at the appointment of an arbitrator, effectively means that I have nothing to say. But
incoming call from Sangha Foster identified by this caller.
I wrote to them and I sent them a notice of arbitration. They have more than notice of arbitration in their home. So whether they have a section 11 that's maintainable without a notice of arbitration, which is very questionable, in light of Your Lordship's recent judgment, which Your Lordship pronounced in April. Second, in my notice of arbitration, I named an arbitrator. They will go to the Bombay High Court, after which they come here. They withdraw the SLP here saying we'll file a section 11. They take 14 months to cure that defect in the section 11, refuse to participate before that arbitrator, who awards my claim. What is the claim? They took 2.5 crores from me. My money. Did not supply a single machinery to me for 5 years, agreed to give the money back to me. When they didn't give it back to me is when I invoked arbitration. And now look, they don't have a dispute. That's why they don't even have a section 21 notice. So how does the section 11 lie at this stage? Without a section 21 notice, how do we issue a notice under section 21? They've never done it, Mr. Chaudhary. What happens is this,
it is issued a notice for arbitration to you on 23rd of December 2019. He actually issued a notice on 3rd of April 2015. They invoked arbitration. Am I right?
That's correct.
What happens is you got no object to that on 16th of April 2019. Yes. And then they on 23rd of December 19, they say that they are appointing that Shivom Gar.
That's correct.
That is wrong. You wouldn't have unilaterally appointed.
So they have
look at the complete fraud in the process. You just unilaterally appoint an arbitrator.
I said if you
have to move with section 11.
That's what I knew. They should come to the court.
Now,
please see the political I am into
Divine. Mr. Divine. You're from Mozambique.
Yes, that's correct.
Why don't you?
I'm the buyer. I'm the one who's paid.
Why don't you both agree to an arbitrator? As we last time said, you both agree to an arbitrator, a retired district judge, a retired court judge, a retired some council here, and we'll send it to a council. You tell us who you want to go to. Because it's not a large team. It's what 2.5 crores.
There's only one very interesting point that comes.
2.5 crores, right?
3.5 crores. The quantum is not very. I accept it. So see, any of these retired judges, I gave 3 names. They give any name. I choose one. The quantum isn't one, and I don't want to detain your lordship beyond the point. I have an award in my favor, but it's
only a paper award. I mean, they're telling me, how could you have just unilaterally appointed?
Because I didn't unilaterally appoint. I said
I had to move a section 11.
Plus, I could have. I'm not saying
you had. That's the only remedy. You can't say I'll appoint whoever I want and he'll be a sole arbitrator.
I said, if you don't object, it will be assumed that you agree to the other.
Not a law. You have to move the court on the 11th. So now tell us. That's why it's come up after what? Nearly 11 months.
That was specifically for this purpose.
Now tell us. You need not take one of the 3 arbitrators they have named. You tell us whom should we appoint. Where is the arbitration to take?
Pune. And you appoint someone here. Plus, can we get the lawyer? Put this. Plus, your lordships may appoint a lawyer from this form.
from our court or?
This point, there is no problem this court. Look, there's only one aspect you also can clarify. Because I actually technically have an award in my field, which is not being challenged. I might add because otherwise, all this will be done.
We'll just say, bearing in mind the arbitration between the parties, bearing in mind the arbitration agreement between the parties, Ms. Archana Pathak Dave, Senior Counsel, is appointed as sole arbitrator to adjudicate upon all the claims and differences. Stop. The arbitrator shall fix up consultation with the parties.
It's deeply I'm so
arbitration is so according to this code of China.
in 22 I'm so. This is a matter about the uniform.
Yes. I remember this. The matter came up last on the 7th of March, I think. Which was mentioned. Before that, 9th of January.
9th of January.
Now, what is the position as Nilbati?
Because what my lords had asked us was to give a roadmap
For the future, yeah.
The suggestion was from our side that the agreement can have Part A clauses which would be there, and Part B would be incorporated by the states depending upon the local laws, which would not be consistent with RERA. So we had accordingly prepared and we had given for Lordship's consideration. Lordship had then directed us that let all the states give their responses and then a final Part A clause can be placed. So this first status report, my lords, after considering all the suggestions from the states, the final Part A clauses are placed for Lordship's consideration. This was filed on 5th of July, my lords. The Lordship would file it, your Lordship's file at page 2665. The additional
bill.
Lordship C file, it would be seal number 34, the last one.
It appears that this, your last report, can you keep it tomorrow or day after, whenever you want, because we'll have them uploaded because we have not seen it. So now you have prepared model builder buyer agreement. Part A is the general agreement, which is consistent with the RERA. Part B will be the state-specific conditions. For instance, Maharashtra is a slum rehabilitation authority, so on and so forth.
Even Haryana,
has it been circulated to all the states?
Responses have been received. We have actually looked into each of the responses. We have given a table also as our first annexure, giving the comments and accordingly incorporating those suggestions in the party notices.
Oh, I see. Can we just do this? Maybe take it up tomorrow or day after, because we have not seen the last. And all three of us, our brief ends at page 2663, 2665. Mr. Mishra, what do you have to say?
I guess it's done a human job. Problem with the era, it's a critical stage of the where because maximum development is yes, but where did I am very good, did I not but our reservations have not been taken into account at all with the greatest respect to the learner. Number one. While other states he is given much greater weight. That's number one. Number two, there are unique features as far as state of Haryana is concerned where your lordships have now laid down the law over the past 3-4 years. My Lord Chief Justice himself. For instance, very simple. When should compensation start kicking on the date of offer of valid offer of possession or on the date when possession is actually handed over. Your lordships are held. The builder may not, the onus is on the builder to give a valid offer of possession after the OC is received. But when the buyer comes to take possession, is up to him. I have no control over that. So, here the onus is sought to be shifted. When the buyer takes possession, the builder must continue to pay. Buyer will never come to take possession because he is getting 9% interest or 7% interest here. So he will wait for 2 years, 3 years, 4 years. So it will, and under RERA, he will get 10% interest.
What is to be done now? Is there any existing objections about
the other problem?
One second. What do we? You are appealing for the state of Maharashtra?
I would like to insert on this note. I don't mind you on Maharashtra. I'm just saying one thing is what should be.
How do we now deal with these, whatever remaining objections are there, Ms. Bhatti and Mr. Maruka, Mr. Upadhyay, what do we do about these kind of objections now which will be there?
Step by step, let's get 3 states. One is state of Nagaland, which notes that because of Article 371 capital A, RERA would not apply at all. Now, I believe I had a discussion with the ministry officials. We are actually in touch with the state government trying to sort out that issue. That may not really come on way. And also, I believe another petition is pending consideration before adoption, where also the RERA implementation as an issue itself is pending in terms of the entire country. Secondly, the state of Tamil Nadu has indicated that they are actually for 2 agreements instead of 1. So we have indicated in the report that 2 agreements cannot really be done. It should be 1 because anyway it's across the country, it's a single agreement, and that's the scheme of the RERA. So, as Rani is concerned, I had the occasion of sitting with my learned senior friend with respect to the matter. My understanding is really about certain local laws like the Haryana Ownership Apartments Act, etc., where they seem to be slightly in conflict. Now, they are placed on record, and I will show the affidavit. A certain order of the government of Haryana saying that because of these conflicts, they have issued a letter internally that the local laws should apply as opposed to RERA, and in the latest Haryana affidavit, a response to these clauses, they have said that the rules, they have amended the rules in a way so that they are able to adjust this conflict. Only my submission, my lords, and I will totally place the lordship's West Bengal judgment also. This RERA which needs to be implemented, in case there's a conflict between state and center, totally the state would have to someday give way to that. So that's a Haryana probably is an area which totally I want to hear. Otherwise, my lords, my submission, otherwise the entire state's all the entire country.
Michael, but my lords, it is consultation and legwork of the ministry itself.
So, perhaps what we do is,
Well, as far as
we'll also see the report of the amicus. We will hear whatever objections Sikh Hidai has, and in the meantime, you take instructions from the state of Maharashtra. And if something remains, we'll deal with it and otherwise resolve it. Because now we'll take that on the record. Prima facie, we should take these agreements on the record and say that all states will have to implement it, because there has to be some uniformity otherwise.
Well, as far as Nagaland is concerned,
Nagaland, they are looking into it. They are in touch with the Chief Secretary, they said.
in fact, we want to refer the matter in terms of the Constitution to a committee which is constituted by the Legislative Assembly of Nagaland, specifically for looking into whether the laws are in consonance with Article 371.
We can, Nagaland specific issue, we can keep aside a little bit.
Right.
Because, we need not allow the Nagaland issue to sort of, because this is vital for the entire country. Otherwise, buyers all over the country are being defrauded by builders. Now, if we have one model agreement, at least there'll be some guarantee that, there is some uniformity in what builders impose on buyers. Nagaland, I quite see, this is Article 371A issue. We keep it slightly out of the picture for the present. And you also take instructions on what is the way forward insofar as Nagaland is concerned.
RERA itself applicability, so when it becomes applicable, it will be done.
So we can create an exception today for Nagaland, that's all.
My friend, and I agree with you. The basic thing, you are constructing. First thing, you should be in the human manner. What is the system, like the system of the policy?
That's all right. Therefore, now the model agreement covers these aspects.
No, my lords, there is a schedule D which says specifications, amenities, etc.
Okay.
my understanding that is where you should fall. It cannot really be otherwise.
It has to be in specification.
Yes, madam. Otherwise,
We keep it on Thursday. What we'll hear you for 5
the column says you have 20 or have 25, I have 25.
All right, we'll look at it then.
May I just make a request? The Lordship may consider kindly have it on next Wednesday. Thursday I'm somewhere.
Not this Thursday. All right, Monday.
Next Monday.
Monday. Okay.
Wednesday is a family marriage, so that's what I am.
Decathlon, 60 plus sports, 6,000 plus products.
Fourth. It should be prepared by Mr. Devashi Baruka. Madam.
The item 23 also, there is an error on our part. We have not filed that affidavit, my lords. That affidavit, we assumed it was filed. It's notarized in February. The accessibility guidelines are being framed after the committee was constituted. We reported your lordships may consider having it next week.
All right.
We'll see that it's filed.
Which is keep it next week.
Report.
Service complete.
Claim is about US dollars 2 lakhs, 200,000 US dollars.
Yes. And on our part, we suggested one arbiter at page 71. This is in Kerala, Tiruvalla. There is agreed, that is page 46. Page 46 is the agreement.
Is Kevin AFP still or that term is expired?
This arbiter, he's based in UK, London.
No, we'll have an arbitrator here.
We are suggested, I am only working notice earlier was suggested at page 71 in that arbitrator's notice, we suggested the name of an arbiter. I leave the lordship.
The service is complete. Bearing in mind the arbitration agreement between the parties, Devashi Baruka, the senior counsel, is appointed as sole arbitrator for the arbitration and conciliation act 1996. So, the petition is according to international arbitration.
Mr. Appear for the respondent. In fact, this matter has been settled. The company has issued a notice certificate to us.
The dispute between the parties
To be tried.
has been settled. Lieutenant Chancellor appearing on behalf of the petitioner, therefore seeks permission to withdraw the petition. Petition is dismissed as withdrawn.
So great. Grateful.
Hello, the petitioner. I have instructions to state that we want to settle this matter. If the matter may be referred to mediation.
We'll appoint an arbitrator now and you can settle it in an arbitration.
There are 10 months, then
Both parties have submitted to arbitration. They have appointed their arbitrator after the petition has been filed.
there in the notice invoking arbitration itself is not on record. They say that arbitration was invoked on 8th March 2022. This itself is not there, Manoj. That's number one. Number two is, Manoj, kindly see their prayer. Because the prayer is at page number 16.
To appoint Mr. So-and-so District Judge, Judicial Member, NCLT.
Manoj, that is their own nominee, Manoj.
We are not going to allow that prayer. We will appoint an arbitrator.
My question is, Manoj, My submission that can be referred to mediation. We first try to attend mediation.
We'll refer it to arbitration, and then you can negotiate between yourselves, try and see if there's some resolution possible. So keeping it pending, we'll dispose it off. And how much is the claim actually?
$303,000 US.
How much does that work?
About 2.5 crores.
It's a tribunal for
It's a 3-member tribunal. You appointed.
They're
It's a 3 members.
as per the law.
Why don't we have one arbitrator, a sole arbitrator? By consent of parties, we may appoint a sole arbitrator. Because 2.5 crores, appointing 3 arbitrators, the entire amount will go in the fees of the arbitrator.
Absolutely.
Right?
My lords, with respect, both parties have submitted to the 3-member tribunal. Both parties have appointed their arbitrators as well.
You want 3 members tribunal?
I don't have 2.5
crores is the amount. If you appoint 3 arbitrators, the arbitrators will consume the entire amount of claim. Bearing in mind the amount, bearing in mind the fact that bearing in mind the amount of the claim, parties have agreed to the appointment of a sole arbitrator to resolve all the claims and differences between them. Accordingly, acceding to the request of the Learned Council on behalf of the contesting parties, Mr. Nakul Diwan, Learned Senior Counsel, shall stand appointed as sole arbitrator under the Arbitration and Conciliation Act 1996. The sole arbitrator seeks his fees in consultation with the parties.
Submission
Yes.
submission will be required that the parties are willing to settle and
Parties are willing to explore the possibility of a mediated settlement. It will be open to them to approach the mediation center of the Supreme Court in the meantime to explore whether a settlement is possible.
But this the mediation would be in Hyderabad and the High Court.
We'll do it here now.
That's the appointment.
Any district judge because the size is. How much is the claim?
38 lakhs.
38 lakhs or crores?
38.72 lakhs.
That's so. Who should be appointed? Tell us.
Any detached may I suggest instead of going for the arbitration, may I suggest for the mediation?
Like this previous matter, we'll appoint an arbitrator. In the meantime, we go to mediation. Now tell us who should be appointed as an arbitrator.
In our letter, we have suggested one Justice Arun Arya at page 35, retired judge.
On the nature of the dispute between the parties, Ms. Meena Nariman, Learned Counsel, is appointed as a sole arbitrator. 38 lakhs we will send it to a junior counsel. Is appointed as an arbitrator under the Arbitration and Conciliation Act 1996. The arbitrator is requested to fix the fees in consultation with the parties. The arbitration petition is disposed of. Learned Counsel have also stated, the Learned Counsel for the contesting parties are agreed that in the meantime they would approach the mediation center of the Supreme Court to explore the possibility for mediated settlement. If this is not achieved within a period of on or before 31 August 2024, the arbitrator may proceed with the arbitration proceedings.
May I please assist? This is an application for appointment of sole arbitrator. The service is complete in the matter.
How much is the claim?
Reflects that.
2 crores 20 lakhs.
The dues are approx 2 crores 14 lakhs 72,000.
They've got a list of arbitrators of the Delhi International Arbitration Center. Small arbitration claim, when you do it as a matter of, you can fix your fees, but you refer it to Mr. R.S. Kiman. For the city takes that one. Check that one.
Okay. 29, please.
What has happened to this? This is the provision of sanitary pads for girls in.
Yes, Lord. And 6 November 2023, my Lord, passed the order.
I remember that. Yes.
Congress had passed these additional directions for the union government to consider before finalizing the.
You are appearing to the union government.
I am appearing to the union.
Yes. Now, what has happened there?
The Lordship, we have written to the states and in compliance with the Lordship directions, we have sought for information. However, there is some information which is deficient and the policy is almost ready, but we need additional time to collect the rectified data on the ratio.
So, how long do you want?
About 8 weeks, Your Lordship.
Ms. Bhatti, what is the position of your Leonard Junior says that the data has been collected, but there is some further work to be done.
Yes, Manoj. The national policy is taking a little time, Manoj. On others, we filed an affidavit, Manoj. They consider having everything together, Manoj. Kindly consider giving us 2 more months, Manoj.
So today we are now beginning of July. So should we keep it early September, 31st of Aishwarya Bhatti.
In fact, my Lord, some of the states like Punjab and other states is doing well, my Lord. So kindly locate their policy also.
Aishwarya Bhatti the other day states that the national policy on of menstrual school going
Adolescent girls.
for adolescent girls in schools, just adolescent girls, is under consideration, is at an advanced stage of consideration by the Union Ministry of Women and Child Development. Full stop. Then it states that a consultative policy will be prepared shortly and be placed on the record of this court within 2 months. Accordingly, these proceedings on. Keep it on a particular date, on a Monday, after the first week of September.
Very great.
My Lord, regarding the toilet also with girls' toilet.
We filed an affidavit on the ratio, but Lordship may consider everything together.
Together,
Lord said consider all this in the policy itself.
All right.
Great.
Item 30, playground. Now, what is to be done here?
Because in this matter, I beg to appear on behalf of the respondent. Because I am aware of the remit of 11. But this is a peculiar case where Miss Elizabeth Kaker was suffering from dementia and thereafter by Alzheimer's. This is what he has said is she was of unsound mind and was not capable of contracting at all. The Vidya Trolia principle where lordships have sort of distinguished between section 11, 12 of the Contract Act as opposed to the contracts which are voidable. So that's my really defense. And
that's a matter to be argued.
But here, my lord, would be a case where she's of unsound mind.
Whether she was of unsound mind,
that will be, of course, subject to medical records which we have placed on record. I am also handicapped because my residence where she used to stay has been taken over by Yes Bank. I am not even able to access my house, belongings, etc. I am communicating with Yes Bank to at least permit me of inspection.
Who are now you're the legal heirs?
Yeah, I am the legal heir because I appear on behalf of her husband.
Circle. Circle. Circle it.
can find anything if I circle it. Let me circle it. I'm like circle. When I'm hanging with my friends, I can circle it. I can find anything if I circle it. See something that you like, you can throw around it. Circle it. See something that you like, you can throw around it.
She's a one-sound mind. Otherwise, विद्यार्थी रोल के carve out that distinction.
Bearing in mind the presence of the arbitration, the existence of an arbitration agreement, this court in the exercise of the jurisdiction under Section 11 of the Arbitration Act 1996 would have to appoint an arbitrator. But stop. The defense of the respondents, who are the heirs of Miss Elizabeth Taylor, that she was not in full possession of her faculties when she signed the agreement, is a matter which will have to be decided by the arbitral tribunal. So we accordingly appoint Mr. Pradhan Parasar, the counsel practicing before the counsel, as sole arbitrator under the Arbitration and Conciliation Act 1996. So the arbitrator may fix his fees in consultation with the parties. The arbitration agreements.
May I request you that that issue be as a preliminary issue, because
Then we can argue there.
all right, oblige.
May I mention a fresh matter in item 31 for the members I mentioned. This is a petition filed by 56 students from Gujarat. We are opposing any prayer for cancellation. The reason that the precondition, so maybe tag along. I have the diary number. Let me take this.
Give the diary number, give it to the court master.
We'll issue notice.
All right. Now we are hearing one. Now tell us broadly. We come back after lunch. Now just tell us broadly. We can't hear all counsel here. We'll have to hear representative now.
Item 1, which is the original item which this honorable court was pleased to issue notice that the petition was entertained. At that stage, because the facts were not very clear, so this honorable court refrained from passing an interim order. If I can just sum up the matter, in my
Now, which is the first? Are you on the first in the group of NEET matters?
That's fine. Item 31.
I said item 31.
31 is fine. 31 is fine. Second case is fine.
31.9 is mine.
I am in 31.4 and I have filed an application for withdrawal of my writ petition.
Anthony has filed reply.
Let's, in 5 of the cases,
साढ़े 5 हम पूछ के आए, पूछो ना 5 नंबर ठीक है। ये पार्ट 1 का 5 नंबर देखना। क्या वजह कोई जाता है सुनो ना, कॉलेज जाता है ठीक है, तो कौन सा क्लास में पढ़ा स्टूडेंट ना? अच्छा कहाँ से? सुनो ना, कल आएंगे, कल चलेगा? साढ़े 10 बजे आऊँगा। कल जाना कॉलेज ठीक है, कल आएंगे, ठीक है, आराम से बोला मैसेज सुनो ना, एग्जाम लेने के लिए स्ट्रिक्ट रहता है, एग्जाम लेने का बहुत स्ट्रिक्ट रहता है।
We'll come back after lunch. Now, tell us on behalf of the petitioners who will be making the main arguments. So, that's the the matter is appearing.
Yes.
Then,
Friends, I am appearing in item 31.4. Liz, I have filed an application for withdrawal of the same millers. I have instructions. Very well. Very well.
got the point, Pravina, we got the point. Allow you to withdraw your petition or dividend.
32 is a little different.
My lord, 31.9 is different. In fact, here the entire sheet
One of the petitioners?
Yes, my lord.
You are saying don't have a retest.
That's right. So I am one of the petitioners, but not that side, right? That's right.
So we will first hear those counsel for the petitioners, a few of them. You have to hear everybody because you won't decide between yourselves because we have to see light at the end of the day. Who are asking for a retest because they are challenging the entirety of the test, saying that the contention of those who urge that the entire test stand vitiated.
Yes, sir.
We will hear them first.
Sir.
You are in that sense on the side of the respondents. You are saying that let there be no retest in the entirety for 23 lakh students. After hearing them, we will hear the NTA and the government. What here? Mr. Percy is appearing for the
NTA and learned Solicitor General is attending for the government.
All right.
I appear in 31.6.
Now, just one second. If we start doing this process, everybody will say I'm appearing in 40.
31.16, not I appear for the. My case is slightly different. At my examination center, 2 of the centers in Meghalaya, the students were not given the papers in time, and there was a time lag of 40 minutes to 1 hour. On same strength,
It was 50 and 63.
yes, like 1563, but we were not given opportunity. 1563 were given opportunity
For a retest.
But we were not given.
You are aware of the facts of Meghalaya, right?
We will file within 2 days. We will file our response also. According to us, minutes the letter shows that there was no 1 minute time lapse and they did not suffer any standard.
All right. We got the point. We got the point now.
My lordship,
1 second. 1 second. Don't talk out of turn. 1 second. Don't talk out of turn. That's not the way to conduct proceedings in the Supreme Court. We will start at 2 o'clock. We will hear the counsel for the petitioners. Then we will hear individuals who have slightly different nuanced positions. We will hear everybody. There's no difficulty, right? So start first hearing those people who argue that the entire test is vitiated and have a complete retest. Because that's the broadest argument. So we hear first the broadest argument. Then we will see people who say that why confine it to only 1563? 1563 can't be the whole universe. There were other people who are similarly circumstanced. We'll deal with those issues also.
Not this COVID at all.
Because
My exam, not the. This is
you are actually, in that sense, you will be supported by the respondents who said don't hear the retest.
42.6 is for the PG exam, for which the test is yet to be held on 11th of August.
So PG will detag.
Well, that's what I'm saying. I will be testing.
42.6 we will detag and hear it separately.
Please.
Mobilize.
Small arbitration claim, we will do it as a matter of, you can fix your fees, but we refer it to Mr. R.S. Hima, former judge in the High Court of Judicature.
Complex.
Ah.
29.
Yes, now what has happened there?
The Lordship, we have written to the state that in compliance with the Lordship's directions, we have sought all information. However, there is some information which is deficient and the policy is almost ready, but we need additional time to collect the rectified data on the ratio.
So how long do you want?
About 8 weeks, Your Lordship.
Ms. Bhatti, what is the position of Leonard Junior says that the data has been collected, but there is some further work to be done.
Yes, my lords. The national policy is taking a little time, my lords. On others, we filed an affidavit, my lords. They consider having everything together, my lords. Kindly consider giving us 2 more months, my lords.
So today we are now, it's beginning of July.
Yes, sir.
We'll keep it early September, 31st of Ms. Aishwarya Bhatti.
Exactly, my lord, some of the state like Punjab and other states is doing well, my lord. So kindly
An application for withdrawal of my writ.
I'm also handicapped because the residence where I used to stay has been taken over by Yes Bank. I am not even able to access my house, belongings, etc. So I am communicating with Yes Bank to at least permit me of inspection.
Well, now you are the legal heirs.
Yeah, I am the legal heir. I appear on behalf of her husband and her 2 children, Ajit and Urshila.
We'll appoint an arbitrator. You can ask, having judged the case, not appoint a former judge or something. We're appointing members of our own court, of our own bar, as arbitrators in these smaller.
I don't know the claim. Maybe the
claim is around about 4.5 crores.
4.5 crores.
In 19, so around 5.5 today.
So my contention may be recorded.
Yeah, that's the
one sound mind. But otherwise, with their role, make carve out that distinction.
Bearing in mind the presence of the arbitration, the existence of an arbitration agreement from us, this court in the exercise of the jurisdiction under Section 11 of the Arbitration Act 1996 would have to appoint an arbitrator. But stop. The defense of the respondents, who are the heirs of Ms. Elizabeth Kerker, that she was not full possession of her faculties when she signed the agreement is a matter which will have to be decided by the arbitral tribunal. So we accordingly appoint Mr. Shadan Farasat, the council practicing the council as sole arbitrator under the Arbitration and Conciliation Act 1996. Full stop. The arbitrator may fix his fees in consultation with the parties. The arbitration.
May I request you that that issue be treated as a preliminary issue, because
Then you can argue there.
all right, public.
May I mention a fresh point item 31 members have mentioned. This is a petition filed by 56 students from Gujarat. We are opposing any prayer for cancellation. For the reason that the precondition. So maybe tag along. I have the ID number. Let me take this.
Give the ID number, give it to the courtmaster. We'll issue
notice
over there. Now, we are hearing one. Now, tell us broadly. We'll come back after lunch. Now, just tell us broadly. We can't hear all counsel here. We'll have to hear representative now.
Item 1, which is the original item which this one was issue notice that registration was entertained. And that is not because the facts were not very clear. So this one court refrained from passing his interim order. If I can just sum up the matter in lines.
Now, which is the first? Are you on the first in the group of NEET matters?
Yes, ma'am. Item 31.
Item 31.
31, one is mine. 31 is mine. Second case is mine.
31.9 is my choice.
I am in 31.4 and I have filed an application for withdrawal of my writ petition.
And then it has filed reply.
Let's in 5 of the cases.
Hi.
कितना वकील कभी किसी की सुनवाई नहीं था। 100 इधर 200 वकील है कभी, बाकी 50 वकील ऑनलाइन हो गए। नहीं हो रहा क्या? फैसला भी 5 मिनट में आ जाए, सुनवाई होगी, खत्म। Hello. एक घंटे बाद कॉल.
We'll come back after lunch. Now, tell us on behalf of the petitioners who will be making the main arguments. So, who does appear?
The first
The Matthew is appearing.
Yes.
Then,
Because I am appearing in item 31.4. Because I have filed an application for withdrawal of the same minutes. I have instructions. Very well. Very well.
got the point, Pravina. We got the point. We'll allow you to withdraw your petition. No difficulty.
But 32 is a little different. Like,
My lord, 31.9 is different. In fact, here the entire
One of the petitioners.
yes, my lord.
You are saying don't have a retest.
That's right. So I'm one of the petitioners, but not that side, right? That's right.
So we will first hear those counsel for the petitioners, a few of them. You have to hear everybody because you don't decide between yourselves because you have to see light at the end of the day. Who are asking for a retest because they are challenging the entirety of the test, saying that the contention of those who urge that the entire test stands vitiated.
Yes, sir.
We will hear them first.
Sir.
You are in that sense on the side of the respondents. You are saying that let there be no retest in the entirety for 23 lakh students. After hearing them, you will hear the NTA and the government. What here?
I am looking
Mr. Party is appearing for the
NTA and learned solicitor is again for the
all right. Now, just one second. If we start doing this process, everybody will say I'm appearing in 42.
I think 31.16, but I am here for my case is slightly different. At my examination center, two of the centers in Meghalaya, students were not given the papers in time, and there was a time lag of 40 minutes to 1 hour. On same strength,
It was 1563.
yes, like 1563, but we were not given opportunity. 1563 were given opportunity
For a retest.
for a retest, but we were not given.
You are aware of the facts of Meghalaya, right?
We will file within 2 days. We will file our response also. According to us, let's the data shows that there is no 1 minute time lapse and they did not serve any assignment.
All right. We got the point. We got the point. Now,
My lordship,
1 second. 1 second. Don't talk out of turn. 1 second. Don't talk out of turn. That's not the way to conduct proceedings in the Supreme Court. We will start at 2 o'clock. We will hear the counsel for the petitioners. Then we will hear individuals who have slightly different nuanced positions. We will hear everybody. There's no difficulty. Right? So start first hearing those people who argue that the entire test is vitiated and have a complete retest. Because that's the broadest argument. So we hear first the broadest argument. Then you will see people who say that why confine it to only 1563? 1563 can't be the whole universe. There were other people who are similarly circumstanced. We'll leave to those issues also.
not this at all.
Because
My exam, not the. This is
you are actually, in that sense, you will be supported by the respondents who said don't hear the retest.
42.6 is for the PG exam, for which the test is yet to be held on 11th of August.
So PG will be that.
Because that's what I was requesting.
42.6 we will be that and hear it separately.
Please.
Mobilize.
Re-Neet का पैकेट्स लागने नहीं आने वाला है. 1 घंटा और लगेगा खाना के बाद.